What I'm handing out is a little bit of instructions on what I'm going to talk about today. This way? Thank you. Sorry, videoing this as well. This is a form that I use in my office, so feel free to take it. I've also, on the back table back there, have this similar packet with my card on it, so shameless plug, if at any point anybody has an interest in discussing this further, that will allow you to get a hold of us and hopefully show you how easy the process is. So, the theme for today is succession, the real life instruction. So, let me ask this question. How many folks have seen the HBO show called Succession? Anyone? Oh, there you go. Frank knows about it. She advised me no one would know what you're talking about. But it is, it's an important and good drama, but the key to it is a little bit about what I'm going to talk about today. So it's a series. This is Logan Roy. Logan Roy is a kind of a self-made man. He's a poor Scottish immigrant. He comes over to the United States and he builds an empire in the media world. News, entertainment, and all sorts of things. And he's got 4 children, some from different marriages, and he's constantly manipulating them to see who's going to take over the empire, who's going to take over the business. The show begins with him having some health problems. And these health problems raise concerns about his longevity, his power, and his control over the business. And lots of people, investors and board members and so on, become concerned about his ability to continue this. And the immediate thing comes to mind: what's the succession plan? And of course, making it complicated as there are 4 children with different mothers, an ex-wife who controls a trust with the children's interest in the company, a current wife who wants to carve out her own independent interest in the company and the fortune. These are all issues, frankly, that spring really out of real life. And it reminds me of, I don't think it's a coincidence that it echoes back to another real life titan of industry, who was a poor Scottish immigrant who created an empire and played his children and family off each other to succeed him in his business, and ultimately was cutthroat enough that the family split into several different factions, and while they remained wealthy, the empire that he built eventually crumbled. Anybody know who this guy is? I guess? Cornelius Vanderbilt, right? There you go. So, the Commodore, as they call him. Probably best known as Anderson Cooper's great-great-grandfather, probably, I assume. So these are real-life issues about what happens at the close of my life, and certainly at the close of my productive life. And so, next slide, this is an issue that has continued throughout the ages. And we've had a number of different solutions throughout the ages, the most familiar of which is primogeniture. So most of you will remember that from history. I don't want to say history teacher, so I have to throw a little history in. Primogeniture means the firstborn son inherits everything, right? That was the law for hundreds of years, if not millennia. That generally changed a little bit over the time frame, so that there became church-state declaration. So if I live in England, the king technically has the ability to trump primogeniture anytime he wants, because I rule by his grace, and therefore if he tells me my heir is such and such, my heir is such and such. Likewise, the church had certain dictates that help define what primogeniture means and what things like legitimacy means, things like that. That gradually developed into what we call heirship laws, and those heirship laws are literally just an order of succession. Succession meaning who has the first right to the goods, to the stuff, and when I die. Those transform over time to what we call intestacy laws. Intestacy is a fancy word for I don't have a will. So the state said, we're going to determine what happens if somebody dies without a will. But the concept of a will develops, in that same time frame. And people are familiar with wills as far back as the Roman times. You'll remember that Julius Caesar had no heir, and so he designated his nephew as his heir, Augustus. And Augustus eventually, Octavian was his name at the time, eventually became the emperor of Rome, because he was the most wealthy person in Rome, because he inherited everything through a will that Julius Caesar had left him. So that's the funny part. We hear about Augustus, but we don't realize really his power came from a will. And that will was enforced by Roman courts, by Roman law, through what we would call intestacy laws and the probate laws. So we developed in the English system, which we are from, the probate court. And the probate court is literally a court that handles things relating to people who are deceased. Anything touching on that is part of probate. And the purpose of probate is twofold. Most people don't know about this. One is to establish an heirship and succession, whether that be through intestacy or through a will. But the second is to provide a place for creditors to come and say, that guy owed me money, right? So that's an important distinction that most people don't think about, is the probate court handles both of those issues. There have been a variety of ways to try and loophole around this issue. And so in early English times, the concept of a trust came up with, and we'll talk about a trust later, but the concept of a trust is, I want things to pass outside of the probate court, outside of the intestacy laws, and I want to have control over this for multiple generations. That was eventually tamped down with a law that still exists from late 1600s called the Rule Against Perpetuities. And what that says is a trust can only last 21 years after someone who is living at the time that I create that trust dies. So, rather odd rule, but it is still the law. It's the law in Texas, it's the law in every state in the Union, because we generally follow English law. That resulted in something that I'm going to call infinite fictional beings. And infinite fictional beings are important for lots of ways. Corporations is an infinite fictional being. Family limited partnerships is something also that we can talk a little bit about in a little while. And then LLCs are limited liability companies. Most people think of those things as a way to develop capital and to establish ownership in trust or in industry. But recognize they also serve a very important purpose in terms of succession. Because once something is in the name of an infinite fictional being, there is no probate for that asset. So, another important tool. Now, why are we concerned with intestacy? Because it sometimes creates results that we don't like. And so, I put a chart here about Texas intestacy rules that deal with persons who are married at the time of their death, but have children from prior marriage. Recognize that this is a very random way to determine how things are going to get divided. So community real property, meaning things that I purchased with my new wife, my second wife, my children, both my prior children and my children from that marriage, if there are any, will take half of the land. And which half is it? It's the half that I own, right? So community property means I own half of stuff purchased during marriage. My wife owns the other half. She keeps her half, but all of my half goes to the children in equal shares. With regard to separate real property, meaning, for example, the most common thing would be I had a house with my first wife. I was awarded that house in the divorce, or God forbid she passed, whatever. The house is mine. The house is mine at the time that I get remarried. Therefore, it is my separate real property. At the time of my death, if I don't have a will, my children from the prior marriage, and again, if there are from the current marriage, take all of it. That house is theirs, period, full stop. However, the surviving spouse has what's called a life interest, right? So the rest of her life, or to me, her life, she would have an interest to live there. It is defined as a one-third interest, a one-third life interest, which no one can tell you what that really means. There are fancy ways to do tables to tell you how much that percentage is. At the end of the day, that means she has no right to sell. She does have to keep up the property. She has no right to mortgage it. It is a shell for her to live in. And most people don't like that concept as a solution. Why we came up with it, I don't know. So, what do? Well, we think. So, I'm trying to think the phrase, the quote that you used last week was, think first and then act decisively, something like that. Yes. Right. So that's always what we want to do when we're talking about estate planning. So estate planning is a fancy way of saying, how do I deal with things toward the end of my life? Here's concerns and goals that I see in my practice. Control of your assets after your death, important. Avoiding conflict between loved ones, very important one in my experience. Reducing costs faced by loved ones, either before you're gone or after you're gone. Honoring family legacies. A lot of times this is property, a lot of times this is other things. Prepare for incapacity and poor health. Most of us will go through a period of incapacity or poor health before we die. This is a reality. We're very good at medicine now. Providing for a spouse or a challenged loved one. We'll talk a little bit more about that. And then finally, avoiding taxes and creditors. This is something that most people, even though I put it at the bottom, most people come in my office, this is the one they're worried about, right? So, next slide. What I tell them is, think about something else. Think about control, cost, and conflict. Recognize that this is a balancing act at all times. So the more control I maintain of my assets after my death, in my experience, the more it is likely to cost your heirs to manage and access your assets. Why is that? Because anytime I put restrictions on how assets can be used, how they can be sold, what can be invested in, the types of things that often end up in trusts and things like that, there's going to be a cost. There's an accountant, there's a financial manager, there's an attorney, each of whom is going to take a little piece of that every year that this continues. So the more control you got, recognize there's more cost for whoever's inheriting. Now, if I have a huge empire, no problem. That probably still makes sense. Restrictions on heirs' control of their inherited assets almost always means more conflict between them, especially where one heir has to administer this control. So this is another thing. We can put things into trust, we can put things into family limited partnerships, but at the end of the day, if one person is controlled, they may all get along fine now. But 4 or 5 years after you're gone, I promise that situation is going to be different if one poor sibling has to divvy up and manage all of the assets for the other siblings. So we're talking about increasing conflict when we increase control, or increase, after death control. And then finally, restrictions on the disbursement or sale of these assets usually result in a loss of control for your heirs, and that typically I'm thinking of your spouse, but it also be your kids, in terms of after you're gone. So if I give my spouse a life estate interest in my house, what does that mean? That means they're tied to this house. They're going to be responsible for the taxes, the maintenance, upkeep, with an inability to sell without the approval of what we call the remainder men. That is to say, the siblings will eventually inherit this. We also have a problem where we potentially create for them an inability to use those assets for their own needs, so for medical or long-term care. So if all my assets are tied up in a house that can't be sold by my spouse, guess what? They've got an issue. They've got an issue in being able to access those assets for what probably you want them to use them for, which is their long-term health care and their medical issues. There's ways around this, but these are just things to think about when we're starting the process. So, let's talk about the other thing that most people are concerned about. The state, or the death tax as we call it, and gift tax. So the good news is almost never do I actually have to worry about this in my normal practice. I deal with people out here, and they're very wealthy people, but there are seldom situations in which people have a real concern about hitting the estate tax. The estate tax for an individual is $12.06 million in assets, this is for 2022, or $24.12 million for a couple. Typically, if we're hitting up against that number, it's because of holdings in real estate. That's usually the issue, right? It's smiling, he knows. And that's because those are changeable. So we'll talk a little bit about ways that you can reduce asset value, not through a will, but through some other planning tools. A family limited partnership comes to mind, but the trust, there's lots of other things to do to basically get those assets down below that number. It's also keep in mind that there's an annual gift tax exclusion available of $16,000 per person. That's something that people don't use enough. At the end of the day, your kids are getting your money, probably anyway. Keep in mind that it is always worthwhile to consider, should we start that process earlier? There's lots of reasons for that. A, we're going to reduce the total estate, which is good. We're also going to potentially allow us to qualify for some types of governmental benefits that we may want. But just generally speaking, you're going to get those assets to your kids in a time frame where they can actually enjoy them instead of getting them much later in life. That said, you always want to have this concept of, do I have enough money to actually cover what I need? So, as a friend of my father's used to famously say, I want to make sure that the last round of checks I cut bounce. So, that's that's one of those things to keep in mind. But once we get into this type of scenario, we're no longer talking about simple estate planning. And so what I want to focus on is a simple estate planning. The reason for that is we're not all the Vanderbilts. We're not all HBO millionaires. At the end of the day, most of us are working people with a simple set of assets. And it is simple and easy to do what I would call the safety net of taking care of the very limited number of documents that we need to sign. So this is the basics. Everyone should have these documents, and they should have them handy. And we'll talk about it a little bit more about the original and all of the above. So a last will and testament with a contingent trust, a statutory durable, what I call a financial power of attorney, a medical power of attorney, an advance directive to physicians, and a HIPAA release for my family members. So those are the basics. There is what I would consider a new basic, and that's called a transfer on death deed. This is literally a new innovation under Texas law. For many, many years, Texas did not have a deed that they officially recognized that did what this deed does. In most states other than ours, there is something called joint tenants with right of survivorship, JTWROS. And what that means is if we're jointly buy a piece of property, if one of us dies, the other automatically inherits. That is not the law in Texas, and it's still not the law in Texas. And it creates well, frankly, a boondoggle for lawyers, right? We got one thing, it's a house, and if somebody dies, we've got to go probate that will, even if that's the only asset we care about, because without probating the will, we cannot clear title to the house. This allows us to avoid it. So we avoid probating a will by keeping your house or property out of probate. There's a really cool little feature to that, is it preserves it from creditors. What do I mean when I talk about that? Most of us have heard the concept of Medicaid coming after your house after you're gone. That is why Texas would not do this. Texas is incredibly aggressive with regard to chasing down Medicaid dollars after the fact. So owning a house, subject to certain valuation limits, unfortunately, many of which might be reached out here, but owning my house does not disqualify me from Medicaid. Medicaid allows me to get long-term care, nursing home care, from the government. So many people are interested in that. I can talk you through any of those concepts if anybody wants to discuss it. I generally think it's not the world's best idea, but we can talk about it. But in this case, because the house never goes into the estate, Medicaid can't come get it. And so that's why for many, many years this was pushed down, pushed down. About 3 years ago they passed it. Now we can do it. Now I can basically sign something that says I want everything to go to my spouse if she survives me, and if not, then my kids need equal shares. It's what some people call a mini will, right? So it's effectively avoiding the need for a will. I would still always say you gotta have a will because it's a safety net to other issues that might come up, but this is a big, big step. The great news is it's revocable, meaning I can revoke it anytime I want to, unlike a regular deed. It has no effects on taxes or mortgages, and it doesn't prevent my ability to sell the property. It's just a designation of a beneficiary, similar to what you would do on a life insurance or 401k. Next slide. In that regard, the goal should always be avoid cost by avoiding probate. So one of the things we talked about is how to reduce cost. Well, the easy way is avoid probate altogether if you can. That's always the best thing. A will never has to be probated just because one exists. If you came to me and said, well, we already did the transfer on death deed, we've got beneficiary designations on all our accounts, we've done the gifting in a way that there's not much cash left over, and we don't have any outside business interest or anything that need to be managed, you don't need to file a will. There's no reason to file a will for probate. Everything's handled. So every time we can do that, we're money ahead. Takes money out of my pocket, so I'm an idiot for telling you all this, but this is the truth because my goal is to try and help my clients with the best way they can. So anything with a beneficiary designation does not go through probate, and the will have no effect on it. So everywhere You can put a beneficiary designation. You should. Bank accounts have something called a POD designation. You absolutely must have that. All of your investment accounts are typically required to have a beneficiary designation. You must do that. On the 401k, remember that your spouse, the current spouse, is always the beneficiary unless a very special form gets filed with the administrator of your 401k. Just had a litigation about this where we had a premarital agreement, not one that I drafted, but there was a premarital agreement. Current wife had signed away all rights to the retirement accounts, but that form wasn't filed and that was signed. Guess what? She got all the retirement accounts, even though she had forsworn them. Even though it was a written document, signed and sworn and notarized by her. Doesn't matter. Cannot trump the 401k designation. Vehicle titles. Those of you that have come to see me know I always say, go look at your vehicle title. There's a place on the blue title where you can actually both sign and say, I want my spouse to be my beneficiary on this title. You can also file a special form that they have down at the county office, county tax office, that says, here's who I want the designation, here's who I want to designate as my beneficiaries for this vehicle. Easy, cheap, why not do it? It's one less thing anybody has to hassle with. We talked about the transfer on death deeds. Something that for any, not just the house, but any piece of property you've got, you can do that. Now, if it's for certain pieces of property, we would do something a little bit different, and that's either a trust or an FLP. So if it's a property that generates income, if it's a property that it is part of the family heritage, we probably would do something like a trust, or an FLP is a family limited partnership. But there's costs associated with that, so we just don't do them willy-nilly, right? Okay. The wills. The main thing, if you take away anything from today, it's that recognize it's way easier than you think to do this. Most people fret and worry and concern themselves with how are we going to do this, and how am I going to fix this, and who's going to get this, and who's going to get that. The answer is, it doesn't have to be that difficult. At the end of the day, the easy solution is always, I'm going to leave everything to my spouse, and then to share kids in equal shares. So if that's your situation, we're talking about a 2-week process. I mean, you come in, give me some info, I send you a link, you fill it in, you send it back, we generate the documents, and within 2 weeks you're back in my office signing all of these wills and other documents we talked about, and we're done. It's because we don't have to worry about, for most people, estate taxes or any of those kinds of things. We just need to make sure that the headaches are as short as possible. It's a little bit harder when we got children from different marriages because we have to figure out how to treat them. In my experience, most people have thought about this, even if they haven't voiced it to each other. So that's typically the issue is, I'm going to step out of the room because I'm not going to tell you what to do, but we need to figure it out. So y'all talk about it, and I'll walk back in and you tell me, what are you thinking? You don't have to decide today, what are you thinking? What are your concerns? All those kinds of things. And we can usually wire around all of that with just a few little, words and clauses in the will. Many people worry about, well, do I have to have a list of all my stuff? Well, no, you don't. Number one, to the extent we can, I want to make sure you designate beneficiaries on everything you own, to the extent you can. Any stuff that's left behind, grandma's china, my gun collection, it's Texas, so that's our thing. Whatever it is, we can do specific gifts that don't have to be in the will. What we can do is we create what's called a written signed memorandum. It needs to be dated and signed by you, typically in your handwriting. And it's instructions to your executor that say, after I'm gone, make sure to do this. And so we'll reference in the will, follow my instructions that I wrote on that memorandum. That way I can change it over time. I got new stuff, I got rid of some old stuff, whatever. As you go, you put in, who gets this, who gets the Rolex, who gets the whatever. We don't have to decide any of that to get the will signed. We can just reference the fact that we'll decide that in the future. And if you don't, your kids will figure it out. They'll figure it out. Burial instructions, that's something, if you have any, that we would typically put in the will. So for those of you that have minor children, we can designate the guardian of our minor children if, God forbid, something happened to both of us. And then a contingent trust. This is for minors, whether grandchildren or children. And in my experience, or in my opinion, it's always required. I always include it, and there's a reason. It's because minors cannot inherit anything. So if there's the second part of anything you remember from today, 1, wills are easy. 2, minors cannot inherit anything. That includes beneficiary designations on accounts. So if you've got a beneficiary designation that potentially includes, as one of the people, a minor, you need to change that. You need to change it to the trust that we're going to create right here, the contingent trust in your will. All that says is money is available for this child, but it's administered by an adult. Without that designation, the child cannot touch the money until they turn 18. And at age 18, guess what? It's all theirs with no restrictions. Nobody wants to give an 18-year-old a bunch of money. That's an insane idea. So what do? We come up with an age, 25, 30, 35, where up until then, the money's available for education, health, welfare, whatever the case may be. The money's available to the child, but they can't go out and blow it on a Lamborghini or whatever. Instead, it gets released to them, whatever's left, at that age. So again, it's almost a no-brainer. There's no situation in which I wouldn't recommend it. The other thing about the wills, it's important to know, is they must be specially signed and witnessed in a legal ceremony. And again, that's why we get paid, is to do those legal ceremonies. They can't be changed except through a similar legal ceremony. So when people go in and they scratch something on the will, just recognize that's ineffective. Scratching through words on a will that's already been signed doesn't work. And having the original will is a must. Always make sure you know where your original will is and that it is kept in a place that's could not be tinkered with or destroyed. Because the assumption is, if I can't find the original will, that means I ripped it up. I revoked it. Had a trial on that very recently, unfortunately. Didn't come out my way, but that's okay. It does happen, and the reality is, it could have been saved if we had simply just kept the original will. Okay. We also mentioned powers of attorney and directives. Most of you are familiar with all of this stuff, so I won't belabor it too much. But at the end of the day, recognize most persons will pass through a phase of medical incapacity prior to your dying. We're very good at medicine, but that doesn't mean they can keep us awake all the time. Lots of times we're out of it. What happens if a tax return or a home refinance, or, again, possibly there's a sale of a home, or a loan from our retirement account that we need to cover those medical expenses? No one can do that without having a durable power of attorney. There is an alternative, it's called guardianship. That guardianship is expensive, it's time-consuming, and it's just unnecessary when you can simply sign a document like this to say, my wife, my husband can handle anything that's necessary if I'm not there. We also need an alternate because, again, in the worst-case scenario of business, consider the scenario of a mutual accident with one spouse dying and the other ending up in a coma. At that point, we've got no one in control of these assets because the person designated as my executor is in a coma. The person who would be capable of handling my affairs up until the will can be probated, etc., is in a coma. We've got to have an alternate on that. And that allows us to make sure that everything has some continuity. The rest of these just pretty much do what they sound like they would do. The medical power of attorney and the HIPAA release are just documents that allow people to be involved in your medical care. The directive to physicians solves a slightly different problem, and that is, I don't ever want someone to come to my child or my spouse and say, you're ready to pull the plug. Those of you who have been through that know there isn't the right answer. Even if your mind and your rational mind says, I know the right answer, your emotional mind just in your heart, it's tough. And it's impossible not to have regrets or concerns that, did I do the right thing? So don't put anybody in that position. Just sign something saying, hey, look, if I get to a point where the docs say I'm gone, they're not giving me any further treatment, they're basically making me comfortable, let me go. If I'm hooked up to machines with no chance of getting off those machines, please let me go. That way, nobody has to make that decision for you. The real decision, and what I have found to be the most difficult part of everybody's analysis in this, is really, who do I trust? And there are some easy answers, but there's some harder answers, right? So if my spouse is alive when I die, my spouse is going to be the executor, that is the person under the will who does things. They'll be the trustee, if a trustee is necessary, for any minors. Probably not. They'll be the guardian of any minor children. We don't really need it if my spouse is alive because those children will be, he or she is the other parent. for the financial and the medical power of attorney, the spouse. Easy answer. First answer is always my spouse. This is where it gets more difficult. Whenever both spouses are deceased, who do we want to put in charge? And the easy answer is if I have adult kids. And I would tell most people, don't pick a favorite, even though it probably seems like a great idea. Consider co-executives, right? That way you reduce the conflict, and any decision essentially has to be agreed. But sometimes we've got a scenario where we've got a child or children who, frankly, we don't trust with that capability. That's okay. Let's find someone that we do trust, and that's the thing. Whoever I would trust to be my executor, I would trust to be my trustee, my guardian, my alternate financial power of attorney. If I trust somebody to handle my assets, I should trust them essentially in most decision-making that would be necessary if I'm unavailable. However, recognize if that person is managing as the trustee of the contingent trust. We talked about another trustee to create funds that go to a different person, especially one to whom they're related. I'm talking about brother or sister, whatever. There's the possibility of conflict. So oftentimes we're going to look outside the family when we have that scenario. We got one kid who just, as soon as that money gets in his hand, he's going to blow it on something. God forbid drugs, God forbid whatever. But we know we can't give him the money. It's got to be held in trust, divvied out over the course of his life. No problem. Find the person who act as that trustee. That's the hard question. And that's almost always what I tell people. Is you're going to leave here and you're going to think about all this, but I'm just telling you, only think of this. This is really the only thing that matters. This is the important thing. Who do I trust? And that leads us to trust. I think this is our last slide. Many people who come to me say, I want to trust. I said, okay, great. First, do you have a will? Well, no. I heard a trust is better. No, a trust is just different, right? So if you're having a trust or thinking about setting up a trust, make sure you've also got a will. Because a will is a basic building block of this estate planning structure. A trust is another layer. And it's another layer that allows us to do very special things. But again, comes with an additional cost. And we talked earlier about, having control increases cost. This is one of those scenarios. So a simple trust, which is called a revocable or inter vivos living trust. It's similar to will, but used during life. So it's going to have very much similar wording to what a will would have. It's going to designate a trustee, which is similar with the executor. It's going to designate beneficiaries, which will be the same beneficiaries that would be in your will. And it will basically allow you and your spouse to continue to control these assets, but not hold them in your name. That's really the purpose of the trust. At the end of the day, I want to make sure that these assets are not held in my personal name, but held in such a way that I've got a little bit of control of what happens to them after I'm gone. So one spouse can't sell the remainder of the house or the land because it's part of the trust. So once I'm gone, my wife can't get remarried and sell my family farm, right? That's, it's in a trust, and that way we protected it. And that's usually where we're looking at it. I got a wrinkle. What I also say is, if you've got a large bank account full of cash, it's probably a foolish idea, right? Just from a liability standpoint, you don't want just big puddles of cash laying around. And investment accounts, retirement accounts are different. But if I have, let's say, more than whatever the insured limit, the 200,000, it's 250 now limit in an account, I'd say get everything over that out and put it into a trust. Have the trust set up a bank account and put that money there. At least it gives that money a little layer of protection. So if I run somebody over one night, that trust money is at least protected from a liability standpoint. So having big wads of cash is very seldom a great idea. It's also useful with real estate, again, especially real estate that is inherited, so that we can kind of keep it in the family. It's also useful with closely held investments, so that would be memberships in real estate investments or small companies, things like that. We can put those in trust. An irrevocable trust is way more powerful, but it has a whole lot of wrinkles on it. So I put something in irrevocable trust, meaning I can't change it, to avoid estate tax. It is no longer my money, period, nor my income, because it's in this other name. Think of an irrevocable trust as one of those infinite beings that we talk, infinite made-up beings that we talked about earlier. It is often used for Medicaid qualification. So if I have a family, for instance, and it's where it comes into play most often is ranchers and family farmers out this way. They are land rich, income poor, right? That's typically how these folks out here live, and where I grew up, and so on. So a lot of times we can solve that problem by putting the land into an irrevocable trust. The downside of that is it is no longer my money. When I say it's no longer my money, I can't be the trustee, I can't be the beneficiary, I have no access to that money. So you better be, and typically you're not supposed to have your spouse or your son or anybody like that in your direct lineal descendancy to be the trustee. So whoever you designate as trustee better be somebody you trust, because technically it just becomes their money. And you've got to designate a beneficiary other than yourself. So it's powerful, but it comes with a lot of catches. The other ones that I'll mention is a special needs trust, and this is for challenged heirs. So if I've got a person who is receiving governmental benefits in some way, whether that be Medicaid, SSI, disability coverage, things like that, and I want to make sure that there's a provision for them, I probably don't want to include them in my will individually, because that's going to disqualify them immediately whenever you die. Now, they can disclaim, right? So anybody can disclaim their inheritance and thereby avoid this issue. And that's another purpose of some of the trusts we talked about is, I've got a son who's got a big IRS lien. This is one I've dealt with before. Big IRS lien. If he inherits anything, it's all going to the IRS, and the IRS is going to sell and force anybody to sell. We want to fix that issue. But if they're just challenged, we want to set up a trust that provides the benefits that governmental subsidy is not available. In my experience, in my opinion, we should create that before you die. So you don't want part of that to be part of the will, you want it to be created prior to the will. And the reason for that is the third-party funding allows a designation other than the government. So once this person has inherited these funds in some way, once it's their money, they can put it into a special needs trust, but they must designate Medicaid or Medicare as the beneficiary and allow them to have access to those funds, and we don't want that. So we do it by creating it before you die. And you should also use it in connection with what we call an ABLE account. This is, again, a new creation of the federal government that essentially allows a certain amount of income each year to be put into an account and to be used without violating the qualification standard for Medicaid and Medicare. It's essentially whatever the maximum Social Security disability that you could receive. Basically, they're going to say, we will agree that receiving that doesn't disqualify you from getting Medicaid or other benefits. And so that ABLE account is really an important thing to consider if you find yourself in this situation. And then the last thing we'll talk about is family limited partnership. This is a complicated structure. It's not that complicated, honestly, but it's used for multi-generational land holding. So typically what happens is the initial holders of this property, they create this entity. They are what's called the general partner of that entity, and they run the entity, and they basically transfer their interests, typically first into a trust and then into this limited partnership. But that means that the assets are held by a limited partner. A limited partner has no right to do anything with the property. I then begin gifting out interest in that family limited partnership within that $16,000 guideline we talked about each year until it's all divvied up among my descendants in the way that I want. And because they have restrictions on what they can do with the property, the IRS acknowledges that reduces the value of the inheritance. And so let's say I've got a $25 million estate, $25 million in typically land. By going through this little process, I can take a 25 to 30% reduction in the actual value as far as the IRS is concerned, and that would take potentially us out of an estate tax issue and back down to no estate tax. So it's a complicated structure, but at the end of the day, it's there for a purpose. typically involves, like I said, ranches and privately owned businesses. So, we got to the end. So, obviously, there's lots more stuff to talk about. You guys have this information. My card's back there. So, if there's anything we can do to assist, I promise it's a quick and easy process, and we can get through it quickly. So, thank you.